We're really excited to be back on track. And today you have a couple of great presenters who are going to introduce themselves. If you have any questions at the end, just come up and see either of us about your CLE certificates and all that happy things. The main thing I want to encourage you to do today is to interact with these two practitioners, ask questions, answer their questions. We're really trying to continue to make this a conversation, not a presentation. And when you want to ask a question, I'm going to run all over the room again, like a fool, and bring you the mic.
So I'm going to defer to my colleague to introduce herself.
Sure.
Go ahead, Eddie.
Hi, good afternoon, everyone. My name is Etty Lee Schaub. I go by the nickname Eddie, like a guy. I'm a senior assistant city solicitor for the city of Providence. I've spent a little bit of time in the Attorney General's office, which I have to say hi to some of my old AG friends. My main focus is civil litigation in tax, which is primarily within the Superior Court. But I have had experience doing some civil rights litigation and other employment litigation in this federal court.
Okay. And I am Matt Oliverio. I am a civil practitioner, primarily commercial litigation. And I've been practicing for 40 years, so I can tell you about the good, the bad, and the ugly of practicing in federal court because we've seen a real sea change over the last 40 years in this particular court. So glad to be here. As Jen mentioned, this is a conversation. We're not going to stand up here and lecture to you. I hate that. So we want people to be interactive, to share their experiences, because Eddie and I are going to do the same thing. But this conversation is not so much geared toward 1983 practitioners, but to those practitioners in federal court on any type of claims. It's really sort of Federal Practice and Procedure 101 to highlight the differences between our state court system and why it's really advantageous to practice here in federal court. Right, Eddie?
Absolutely. Yeah. I love practicing in this courthouse, and not just because of the facilities, because they're pretty, but the people in it really make it.
So we want to just do an overview of some of the topics that we're going to cover. Eddie?
Sure. So, of course, we're very excited to talk about the federal court writ large and how welcoming it is. And we're excited that you're here today, and I'd like to welcome you to the federal court. And then to the extent that the rules are going to be different in this courthouse as opposed to the one on Benefit Street, knowing the rules of the game, how to actually litigate in this courthouse will be very important. We'll go over some of the highlights and lowlights there.
Yep, the highlights and the lowlights. And then we'll talk about
local rules.
The local rules, the differences between, and this is important because if you practice in this court, you're going to come across a lot of practitioners who are from other jurisdictions. Mm-hmm. So they have to be admitted pro hoc vice. They don't know our local rules. They don't know our judges. They don't know our clerks. They don't really appreciate the smallness of our court and the camaraderie among the members of the bar, and as between the members of the bar, the clerks, and the judges. And in particular, in the last 15 years, it really is like a family, a home for the Rhode Island civil and criminal practitioners here. So you have to educate them on our local rules and the differences. I mean, something as silly as, I get this question all the time. Oh, we got to file this motion to dismiss, a 12B6 motion. What are the page limitations? Page limitations. Well, the fact of the matter is there is no page limitation in our local rules. Other jurisdictions have page limitations. We do not. If you're trying a case and you have to do a post-trial brief, page limitations? No page limitations, except Judge Smith may say, that was a 6-week trial, no more than 60 pages on the post-trial brief. So those types of things. Yeah. So we're going to talk. And then lastly,
the pro bono panel. Yeah.
Because there is a way for all of you, and I think really important for those who are more junior at the bar to really get involved and see what it's like to try a case in federal court and to get that experience. Because let's face it, I think that's the big gripe here in Superior Court and in federal court, the younger practitioners are not getting the experience of Lynette Labingers, right? The Barbara Hurst.
I won't try cases, but I want to add that one of the things, if you do a pro bono case here and you are a junior member of the bar, we will recruit a more seasoned member of the bar. I can't even talk in this. We will recruit a more seasoned member of the bar to enter on the case with you.
Yep.
So you're not left on your own. It's really a great way.
So you're not flailing.
One, litigate, and also to start litigating here.
Yeah, if you have less than 5 years experience, a mentor will be assigned to you on the pro bono panel. And that's,
Just want one.
pardon me, Barbara?
If you have more than 5 years experience.
Yeah, or you, that's
Yeah.
right. That's right. Okay, so federal court, Eddie, let's have at it.
So
Why do you want to practice here in federal court?
So I've had plenty of experiences practicing in different courthouses. I went to law school in New York. I grew up in New York. I've practiced private practice in Massachusetts and here in Rhode Island. In college, not true trial experience, but I did mock trial in a number of Midwestern states, and you think they're going to be super friendly there. Nowhere is as nice as this federal court right here. I can tell you that hands down.
So
Easily.
yeah, so when I first started practicing in 1985, and Lynette and Jerry DeSales, you're here, you're going to appreciate this. No one wanted to practice in this court. Why? Well, probably with the exception of Judge Patine, who was just a dear man and just a real gentleman and was great to try a case in front of. Some of the other judges were not as accommodating as Judge Patine. They were, candidly, intimidating. Why? If you filed a motion to be excused because you were going on a vacation, if you had to attend, a graduation, a college graduation for your son or daughter, routinely those motions to be excused would be denied if you were, on the trial track. They made it very difficult to try a case here because they held you very strictly to timelines, and they were very tough on younger practitioners too. If you didn't know the rules of evidence, they weren't afraid to let you know and kind of put you in your place. So it was an intimidating place to practice. I will tell you that changed really when, I would say, Judge Smith came into the picture in 2002. So he was a practitioner at a large firm. He came from a family of judges, and he kind of opened up this courthouse, and he instituted a lot of programs. Then you had Judge McConnell, Mary McElroy. These people were lawyers that were in the trenches, both in Superior and in federal court. And I think if you asked Judge McConnell, did you enjoy trying cases in federal court? He'll tell you no. And so he was dead set on changing the culture of the court. And I think now, in the last 15 years, you've seen an evolution where the judges are very accommodating to the practitioners, and they listen to you, and you can talk with them. The clerks. What about the clerks? What have your experiences been with the clerks?
I think that Nora has been so amazing. I mean, just working to set this up today with the people that work in this courthouse, they've been so friendly. I have had experiences in the past in other courthouses where I'd ask for help from a clerk, and they're a bit overwhelmed, overworked, not necessarily as friendly as they are here. I'd rather say that the people here are amazing rather than
And they throw great parties, by the way. They throw great parties. So our holiday party, we have cocktail parties after each litigation academy, which we'll talk about in a little bit. But another advantage to coming here to federal court, let's talk about state court. With the exception of the asbestos calendar and the business calendar, you don't know who your motion calendar judge is going to be. You don't know who your trial judge is going to be when you file suit and your trial is 5 years down the road. Here, you get assigned, right when the complaint is filed, it gets assigned randomly to a judge, and you have that judge from cradle to grave. And let's face it, we have 3 judges now and 1 senior judge. And so that's not a lot of judges, and they handle a lot of cases. So you get to know the judge. You get to know their foibles. You get to know their idiosyncrasies, and you get to know all about their 16B and scheduling orders and how they're going to impanel a jury, if they let you do it or they're going to do it.
But even more importantly than that, they're not going to have to relearn your case every single time you have a motion. I can tell you the number of times I've been in front of different motion judges in Superior Court where I have to spend time, nope, actually that happened on this year, not that year, having to reiterate all of the facts, both verbally and in my writing, just because it's a new person I'm trying to educate. Here, they know about as well as you do.
And here's a question I want to ask everyone in this room. And some of you may be plaintiffs practitioners. So of those who are plaintiffs practitioner and you want to bring suit on behalf of a client, whether it's a 1983 action or a personal injury, wrongful death, or discrimination claim, you know if you bring it into Superior Court and it's not on a business calendar, but just a regular calendar, you know it's going to be 3 to 5 years before you get to trial. When you bring it here, you know it's going to be on the outside 18 months to 2 years. In a lot of cases, it's 1 year. If you're a plaintiff's practitioner, where would you rather be? Do you want to move your case? Especially if it's a contingency case and your fee is contingent on the outcome of the case. Do you want it languishing in state court?
I'm seeing a plaintiff's attorney I know with their head shaking, like, absolutely not.
Go ahead, Mark.
Yeah.
It's like the answer to all legal questions. It depends. It depends, right?
Yeah.
So I agree with everything you've said so far, and I really like federal court a lot. Here's what I don't like about it from a plaintiff's perspective.
Yeah.
Plaintiff solo practitioner.
Yep.
You have the scheduling orders, which I think is a necessary evil, and many of us don't want to admit it, but it forces us to move the case.
Yep.
That said, I had a case a few years ago in state court where we were preparing for trial. And guess what? I saw something that I never saw before in some documents I was reviewing. And because there was no scheduling order, we were able to do something about it. We were able to inspect my client's personnel file. In federal court, that wouldn't be allowed because the discovery deadline had already passed. And we discovered that they had whited something out in her personnel file that I had seen the document 100 times and never noticed it until I was preparing for trial. The other issue is we had a case in federal court, a disability case, very good case. And my client's treating physician did not want to cooperate. We needed him to just say that he diagnosed her with bipolar disorder and to talk about what it was. He didn't want to cooperate. We were in federal court. I had to hire Barry Wall and pay him $17,000 to do a forensic report. Because you have to issue a report in federal court. And we settled the case, and that came out of my client's end. Yeah. So those are a few
some of the considerations. Yeah.
And there's one other thing that I'm never been completely clear about is whether prejudgment interest at the state rate applies if you choose to bring it in federal court. So 6 years in state court, you get your 72%.
Well, that's a good point. That's a real practical thing that you have to consider is the 12% per annum prejudgment interest. Thanks. Who else had a comment? Anybody else have a comment?
I'm curious, Chloe, do you have a...
Chloe?
Yeah, I just heard your opinion the other day. I don't want to put you on the spot.
Go ahead, Chloe.
I just say I would say that the scheduling orders, yes, are a necessary evil. I hate being in Superior Court because there's a lack of scheduling orders because I know that nothing will happen.
That's right.
I can't get defendants to respond to me on anything, and sometimes my cases get backburnered. So I would prefer to be in federal court because it forces everybody to move.
Yeah, I mean, the cases do progress.
State court.
Appreciate it.
If they're specially assigned and definitely on the business calendar. What about the hearings?
Oh, yeah. So
what about hearings?
So maybe it's just a personal preference, but I love the ability to sit in a comfy, cozy chair and speak before a judge when he's ready to hear me and not wait for an hour, hour and a half. Oh, wait, we're booked up. Come back at 2 for a hearing for a judge. Whereas here, you can get a time slot and be on Zoom, which is so nice.
And most of your hearings now, and you'll see, I'll pull up a hearing notice later in the discussion. It was a preliminary injunction, and it was on it was a Lanham Act case where I was defending the defendant, which was a Chinese corporation. And we get a notice of a preliminary injunction, and we did all the paperwork. I thought, okay, well, preliminary injunction is usually an evidentiary hearing, isn't it? It was in front of Judge Lisi recently. So I'm expecting, I call the clerk, her case manager said, well, no, I think the judge it's going to be a Zoom hearing. I said, it's a preliminary injunction. Doesn't she have to size up the way? It's going to be Zoom. Well, we get to the hearing, and the judge didn't want to hear any witness testimony. She decided on the paper and the affidavits, and she let us know pretty quickly how she felt about the case. So that was interesting.
But you knew exactly who to call when you had that question.
Exactly.
And that's another benefit of federal court. If I saw that there was going to be a hearing scheduled for state court, I know some judges like Zoom or WebEx, and I know some of them don't. I know some of them sometimes sit in different calendars and different days of the week. So are we sure it's still going to be in Providence? It's basically a guessing game. Then try and find the clerk, trying to get them on the phone, trying to send them an email, hoping they see my email in time, or you call the case manager here.
Well, so I'll tell you a quick story about a case manager. I'm on trial in front of Judge Smith. It's an environmental case, and testimony is going on for 6 weeks. It's a big CERCLA case, and I'm local counsel. And that particular day, the testimony didn't involve my client, so I asked Judge, could I be excused? And Nishi, the case manager, said, Matt, send it to me. You know, I take care of those motions. Basically, she told me, I decide whether you're going to be excused or not. The judge doesn't even see it. I filed the motion, boom, like that, it was granted. So I had a day off. Anyway, but one of the huge benefits of practicing in this court is you get the magistrate judges to do mediation. Absolutely. And you can do it really at any stage in the proceedings, any stage. And they're excellent. They're excellent. So Judge Sullivan, Judge Allman, I can't tell you how many cases I've had in front of Judge Sullivan where suits filed. Plaintiff says, Matt, I said, I'm going to file a motion to dismiss. What do you want to do? Can we have an early mediation? You mean before I file my motion to dismiss? Okay. Contact any of the clerk. You contact Judge Sullivan. She's like, yep, it's confidential. She'll fit you in. And you don't have to pay a fee to a mediator. And I bet you, dollars to donuts, that she and Judge Allman probably have a 60% pass rate, right? Like they'll get them settled after 1 or 2 mediation sessions. They have a high rate of settlement. So that, I think, is the other benefit of being here. Whereas in Superior Court, who do you want to use as a mediator? Oh, who's available? Well, they're not available. How much? Geez, they're $500 an hour, right? Isn't that a retired judge? Why are they charging $500 an hour? So you get the message, right? Okay, here we go.
All right, so we're going to talk a little bit about the rules generally. So, of course, since you're in federal court and not state court, you'll be using the federal rules of evidence and the federal rules of procedure. So just, think federally, act locally. They are, of course, still similar. That's why in law school we're usually taught the model rules of evidence, the model rules of civil procedure. But some of the differences that we'll go over briefly are subsequent remedial actions is evidence, expert testimony, and as well as in the rules of evidence and discovery disputes.
All right. So, Eddie, I'm going to ask you, I've got a case. Okay. All right. And I'm a tenant. And on a three-decker, and I'm coming down from the 3rd floor, and the floorboards are rotted out on the stairwell, right? And so I go through, I fracture my ankle. It's a serious injury, right? The very next day, the landlord comes, puts up a whole new staircase. How is that treated? Is that admissible in federal court for purposes of establishing liability? How do you handle that?
So for liability purposes, no, not at all. As opposed to in Rhode Island, yes, absolutely. So if anyone here studied evidence outside of this state, you might have gotten what I got from my evidence professor, which is talking about you can never admit subsequent remedial actions to admit negligence unless you're in Rhode Island.
Yeah, right.
Which is a very unique aspect of our rules of evidence. But here in federal court, you cannot unless for certain purposes. It's usually, of course, ownership, for impeachment purposes, for control, or the feasibility of precautionary measures. Of course, meaning whether or not the failure to, for example, fix the stair was reasonable or unreasonable.
Right. But let's assume you get that into evidence for a particular purpose.
Well done.
Once the jury hears that, what do you think the outcome may be? Even if there's a curative or some sort of instruction to the jury during the jury instructions.
Well, I think the instruction itself is going to highlight it for the jury.
Exactly.
And then the jury's going to go, oh, wow, they could have fixed it, and they did it a week later, and they could have done a week before. Come on.
Okay.
That's what I think.
What about expert opinions, 703? And we just want to highlight some of the differences in federal court versus state.
So in Rhode Island, when you present your expert witness to provide testimony for your client, the underlying facts shall be admissible without testimony from the primary source. So when you're thinking about a primary source, it could be whatever treatise or other documents that your expert relied upon to come to their expert conclusions. They can go ahead and talk about that. In federal court, not so much.
Yeah.
And in fact, you can bring in their conclusions first and just stop there. And only for the purposes of understanding their basic conclusions can you bring out the underlying facts and data.
So one judge that didn't adhere to that was, God rest his soul, it was Judge Laguerre. He brought over the Superior Court rule with him when you tried a case in front of him and put on expert testimony. And it was very difficult, and he made it very difficult on the civil practitioner to get the expert opinion in. You could try all the hypotheticals you wanted. If it wasn't in evidence, it was very difficult. So he was tough to try a case in front of. But the one thing with Judge Laguerre, you learn the rules of evidence. Mm-hmm. So that's just one example. Mm-hmm. Discovery process.
Right. So if you're mainly practicing in Rhode Island, this process is straightforward, although not necessarily well documented. Right. So you can and should, in fact, e-serve. I would recommend e-serve through the Tyler Host Services. It's really great. You get a time stamped, and then when you need to send a Rule 37 letter, you can say, see attached when it was served upon you on this date and at this time. And so I know that you have it. Right. And then after the Rule 37 letter, then you file your motion to compel, which is through the court as well. And then after you file your motion to compel, you file your motion for conditional order of dismissal, which I'll pay anybody here $100 if you can find where that is in any civil court procedure, rule, statute, anything. Nobody wants $100? Yeah.
You can put up the first.
Yeah. It's like, please produce these now, pretty please.
So,
and then, of course, you could actually get judgment and dismissal.
Nope. All to the first PDF, please.
The first.
But that's very different in federal court.
Yeah. So in federal court, let me just, can we go up to the first PDF? Sorry again. So in federal court, they try to dispense with all that,
Mishigas, if you will.
Mishigas. Yeah, thank you. And in fact, you cannot, in federal court, file a motion to compel until there was a standing order that was issued. Yep. Sorry about that.
Here?
All the way.
All the way.
Yep. There was a standing order that was issued, I think, in 2000.
Was it 13? 18?
So much for the smooth tech show today. Not you. There we go. So here's the standing order. Just this was issued. Yeah, when Judge, not too long ago, I think a few years ago, 2019, the judges were tired of dealing with motions to compel and discovery disputes. And there are many in federal court, only because they tend to be more complicated cases. They're complex. There's a lot of disputes over discovery, particularly with attorneys that practice in other jurisdictions, Massachusetts, New York in particular. They're very aggressive. And the courts, our court said, no. As of this notice, no discovery motions will be filed until after the party in good faith tries to resolve the matter with opposing counsel. Okay, the meet and confer. Let's do the meet and confer. But we're going to go beyond that. We're going to say, and if that doesn't resolve it, you're not going to file your motion. You're going to ask for an informal conference with the court. So you have to you do an email to the case manager. Rule 37, I'm prepared to file a motion, but I know we have to comply with this general order. So we have to have a conference with the judge. And I've done that on many occasions, some very complicated cases. And the judge will say at the end of the informal conference, well, I can hear Judge Smith saying this, well, I think we're making some headway. You know what? Don't file that motion yet. We're going to have another conference in 2 weeks, and I want you to continue working. I had a case with him one time. It was an environmental case, and I think we had the informal conference over a period of 6 months. No one filed a motion. So it got resolved, though. The issue was resolved. Okay. So can we go back to the PowerPoint? Great. Okay. So that's the difference on the discovery process. Okay. And don't forget now, when you file your motion, if you file your motion to compel, you have to also include with it the discovery that's in dispute. Yeah. Otherwise, the court won't have any idea what you're talking about. Can we go? Yeah, go ahead, Mark.
I don't know if you guys are going to get to this, but one big difference between federal court and state court when you're filing is that in federal court, when you enter your appearance, you automatically get notified of all court filings, while in state court, under the Tyler e-filing system, you have to add yourself as a service contact.
Yeah, that's a good point.
That's a great point.
That's a very good point. You're right. It's automatic in federal court.
Yeah.
But you have to add yourself as a service contact in state court.
There was somebody who didn't add him. This was really unfair, but the Rhode Island Supreme Court affirmed so his case got dismissed because he didn't add himself as a service contact, and they filed a motion to dismiss, and he never got notification of it. And the Rhode Island Supreme Court affirmed the dismissal and said, too bad, that's on you, which I thought was really harsh.
Megan, can you go back to the
PDF?
another
just shows how friendly it is here, right? It's like you're in the case. Another way that they're friendly here. You're in the case. You're getting information about the case.
That's it. Okay. All right. One I didn't add in the outline for why it may be preferable. Another reason why you want to come to federal court if you're on the defense side. So let's say Chloe files a discrimination claim in state court, although I don't think she would. I think she'd come here. But let's assume that she does. Her office brings a claim, and she asserts some federal cause of action. So I now have grounds to remove it to federal court. Why would I want to bring it in federal court? And looking at the complaint, I question whether there are sufficient facts alleged, that she doesn't allege a plausible cause of action given the allegations. Remember the 12B6 standard in federal court, the Twombly-Iqbal standard, right? Plausibility. It's, you really have to assert facts and not conclusory allegations in federal court. In superior court, our Supreme Court, although it's had opportunity to adopt the Iqbal-Twombly standard, they have yet to do so. The latest case was in 2023. And they had the opportunity. They elected not to. They still use a reasonable doubt, all the preferences in favor of the non-moving party, et cetera, et cetera. It's very difficult to have a case dismissed under 12B6 in state court. Whereas if you're a defendant in federal court, you really want to examine the complaint because you're going to have a better shot under Iqbal and Twombly, the plausibility standard, to have the case dismissed outright. And I will tell you, our judges, one was a public defender, one worked in a mass tort law firm. They all come from different backgrounds. One was a labor and employment attorney, but they have all shown propensity to, if the complaint doesn't have sufficient facts, they'll apply the Iqbal Twombly with no problem and dismiss the case. You see that a lot in employment, in the employment realm.
So I just want to jump in super quick because I had the pleasure of being taught by Professor Alex Reinert in law school, who actually argued the Iqbal versus Ashcroft standard.
Oh.
And so, yeah, so just you really do want to look at some of the nuances there between the Bell Atlantic versus Twombly, which our state court has embraced, and of course the higher pleading standard, both for defense attorneys looking to practice here, but also for plaintiffs' attorneys looking to file a complaint in this courthouse. Right. You want to be very mindful of the Iqbal versus Ashcroft standard.
Yep. Great. So here's just, any questions? Nobody? Okay. So just a couple of things that I wanted to point out, and these are from our local, some of the general and then the civil rules. We didn't focus on criminal because neither one of us are criminal practitioners, but just a couple things to bear in mind. There's a local rule, 102, and that's for filing documents under seal. What happens in that case, so let's say you want to attach medical records, confidential medical records that you want to reference in a complaint or in a motion to dismiss or whatever. But, that's someone's confidential healthcare information. So you want to keep it that way so that only the court considers it. But it's an important point for you to make to support your position. You have to file a motion to seal, and you can then you have to file that first, and then anything that you file thereafter is provisionally sealed. So it is protected. But if the court ultimately determines it's not subject to a motion to seal, it's not a confidential document, they don't accept the document. It gets kicked out. Yeah. So that's pseudonyms. You can use that, but you have to file another document confidentially that provides the true name. Okay, so the person, that Jane Doe, has to provide some evidence to the court, which remains sealed, of the true identity of the party.
Yeah, okay. I just want to go back to the confidential records. I know that as a defense practitioner, when I receive plaintiff's medical records and I want to use them to either support a motion for summary judgment, a motion in limine in superior court, I have a panic moment. I go, I have these, and I know I can mark them as confidential, but they might live somewhere on the server, and I don't want to do that to a person, even though I have their records and they're suing the city. Yeah. So I will try to separate those out and send them to the judge and to opposing counsel as separate attachments and just never attach them. This provides me with a significant level of confidence that I'm taking the steps that I need to take to behave responsibly with somebody else's medical records.
That's a good point. And you have that level of confidence. In state court, I've done that. I'm sure some of you have tried to file things confidentially under seal. It's a little gnarly. Yeah. It's not as clean cut as it is in federal court. Okay, electronic devices. Thanks, Megan. So no person shall photograph, record. Okay, you can't do that except for ceremonial proceedings, court proceedings. Certain individuals are permitted. If you want to go up to the next page, Megan, please.
While we're scrolling, although you can't bring those electronic devices in, it's been a delight to be able to watch a lot of the really interesting motions being argued before this court, as they will be streamed on Zoom. So you can actually go to the court website and look to see what, if anything, will be heard on that particular day on Zoom and log in and watch it. And that's how I got to watch some of the recent hearings on the suit by the state of Rhode Island versus the current presidential administration.
See, there you go.
Yeah.
Yeah. Wow. Cell phones. If you just scroll down. Yep. So nope. Sorry, Megan. Right there. Probably up until about 10 years ago. I don't know if some of the more senior practitioners remember, we would take our cell phones and the marshals would seize it. And there was a locker right out there. You could not bring your cell phone into the courtroom. Well, now, so many people depend on, you're trying a case, you've got a colleague, there's a witness issue, you need to be notified. Now it's okay to use your cell phone, but you cannot use it if it's going to be disruptive to court proceedings. And so that's just one thing we wanted to highlight.
Which is a friendly reminder, please turn your cell phones onto silent.
Yeah, thank you. Next, please, Megan. Next page. All right, let's talk about the form and filing of this. This is the out-of-state practitioner. They're like, okay, you get a draft of a motion, and it's like 24 point, and the footnotes are, 15 point. No. 8.5 by 11. Double space, 12-point font, footnotes 10 point, period. Notice no page limitations. No page limit. Go ahead.
Can I use a fun font?
Yes. Yeah.
I don't think so.
I don't think, most people use Times Roman.
Mm-hmm.
I haven't tried anything else, but I don't know. I don't know the.
Several filings
In different fonts?
I think it's great.
That is wild. Please use a serif font at least. It's easier on the eyes.
All right, now you got to the point, you got through your informal conference, you weren't able to resolve your discovery dispute. Now you're filing a motion to compel. Unlike state court, now finally they've amended this rule. You can do it all in one document. Motion to compel, your memo, your citations to legal authority. And here it is. You file it. The response is due 14 days. A reply is permitted by right 7 days thereafter. Oh, I need to file a SIR reply. Got to get permission from the court. You got to get permission from the court. By the way, this rule is kind of silly in the sense that once you file the motion, you get the notification from CMECF. It has the time limitation. It tells you when you have a right to file. And I will tell you this, every time I get one, they generally don't align with these rules. They don't. They're either shorter or longer. And I think it depends on the judge or the case manager. So it's kind of academic.
But also, meanwhile, what a relief to not have to wait. If is it Saturday? Wait, the Sunday. What's the holiday after? Is that a federal holiday or is it a state holiday?
Right.
Well, how many days for that? Do we count when was it actually? They just tell you it's due on Thursday or it's due.
Massachusetts federal court doesn't do that.
Oh, okay. So we just heard from the audience. Massachusetts court, federal court doesn't do that. Oh, what a service this court has. This is great.
And then just wanted to highlight the local rule 26, the 26F conference, which is the discovery conference, which your discovery plan, which is also embraced in the federal rule, right? Federal Rule Civil Procedure 26F. You better have a conversation with opposing counsel before you get to your scheduling conference, your Rule 16B conference, because the judge will not be happy if you don't have a plan. Like I said, a lot of the cases are complex cases, and you may face issues of spoliation if it's a product you want it preserved, or just electronic data that you want preserved because it may go missing, or the one party doesn't have a document retention program, so every 90 days they purge their email server or whatever. So those are the type of things that you want to I wanted to highlight that for you. The impanelment of and communications with jurors. So here's now, every judge is different. I think Judge McConnell is more liberal with allowing attorneys to interact and do the jury impanelment. Judge Smith likes to have a little more control. I'm not sure about Judge Lisi. Probably she's like McConnell because she was a public defender, and they like to cozy up to the jury. But in any event, you need to submit a list of any questions that you intend to ask prospective jurors. That has to be submitted. That's not required in state court, but this is a difference in our local rules. You have to do that. Can you scroll up down to the next? Yep. Here's one thing I wanted to point out. As if you try cases in state court, you have to ask permission to the judge. I'd like to speak with the jury after. I want to know, why they rendered a verdict against my client for $3 million. I want to get into their head and communicate with them. Here, no, communications. No attorney, party, or agent shall communicate directly or indirectly with a juror during or after the trial of a case. Strictly prohibited. The only individual who's permitted to speak with the jury is the judge, the presiding judge. Okay? And then one last thing on jury and jury instructions. Keep this in mind, another local rule. You have to, when you're submitting your jury instruction, you got to make sure that you ask for the instructions you want or you object to a requested instruction. If you don't, your argument on appeal is waived. Well, the judge should have instructed on this. He misapplied the law. Well, if you didn't propose or you didn't object, you're waived. You're done. Okay? All right. Now I'm going to hand it over to Eddie, who loves summary judgment motions. And this is unique to our court.
It's unique, and I've had a number of conversations with colleagues and practitioners about the pros and cons. So I think the cons are pretty straightforward to see. It's a lot more work than a typical stay motion for summary judgment. You just, depending on if you are in front of the business calendar, in front of Judge Leach, he'll want to give some type of schedule when you'll file, when there'll be objection or reply, and a hearing date in advance. If you're just before the regular motion calendar in Providence, you're going to try and get a date from the clerk. Hopefully it's within the next 6 months, and it's outlined in the civil rules as to, or the new administrative rule as to how the timing for the reply and objection should be, and the binders that we now have to make, which are super fun.
Yeah.
But in federal court, first you have to come up with a statement of undisputed facts, which opposing counsel should dispute, which, as just the concept itself, is a struggle to understand, I think.
But when you put that together, don't you have to have a citation to
every single fact you intend is undisputed?
So whether it's a document, an affidavit, deposition testimony, you have to cite, or that's going to get kicked out.
Yep.
Because the court is not going to take your word for it. They want to see the supporting document that makes that an undisputed fact.
So,
right?
Yeah, absolutely. And I've actually seen references to websites, public records, YouTube videos as well, coming in on undisputed fact citations.
I haven't seen that one yet. Whoa.
Yeah, so every single fact that you put into your purported undisputed fact section has to be supported by evidence. And then you give that to opposing counsel. And that's when you dispute those facts. You go through every single one. If you are in opposition to that motion for summary judgment, you look to see which ones that you dispute, and then you have to set up your own statement of disputed facts that then also identifies the evidence to support for every single one of those matters. And then you can also supplement with your own statement of undisputed facts, which I think I've seen a few times. Yeah. And then it goes back and forth. And then you file your motions, and then you get a hearing, and then you talk about it. So why the insanity?
Yep.
Why so complicated? It's a lot easier for the judges to actually understand what your point is. Because remember, the standard for summary judgment is taking all of the facts in the light most favorable to the non-moving party. Is there an actual dispute as to law and facts? Yeah. Anything.
Yeah.
And if you're just like, nope, the light was red. We're all agreeing the light is red for the purposes of the motion.
Can you go back to the PowerPoint?
And you can just move on to the actual application of law. We have a question.
Yeah.
No, go ahead.
Do you know whether that's kind of the practice throughout federal courts, or is that just our federal court?
Boy, Josh, that's a good question. I don't. Lynette would know.
Yeah. Hold on.
I know that our local rules committee has been reviewing and proposing changes for a few years. I believe it is a common. The exact language may be different from one place to another, but it's common. And to me, it's very burdensome and cumbersome, the way it's done, especially because everything has to be in a separate document. But efforts have been made to try to streamline it, and so far it hasn't been terribly successful. And it's something that everybody wants to. If anyone has any good ideas, they should.
Well, I think the counter argument to that, Lynette, is when you go through that exercise, it really forces you to hone the issue and to prepare for trial. So let's say the motion's denied. you basically have, through your summary judgment motion, a trial notebook that you've already prepared. So you learn your case, you really get into the weeds of the case, and you remember, oh, here's the citation to that person's deposition testimony. But it's been that way since I've been practicing, and everybody kind of hates it. You're right.
The concept obviously makes sense because of what the legal standard is. It's the formatting that you have to have the numbers and they have to correspond. And then if you're doing your own statement of undisputed fact, they have to start with the next number. And then you have, it just gets very cumbersome.
Yep.
And to me, at least, I've seen in other jurisdictions where they have like motions to compel, which is a different thing, but you can't file them until everybody's assembled everything, so that you prepare your motion, then there's the response. And
well, that's like
your
Massachusetts State Court.
Yeah. So that it's possible to put it all into one set of documents as opposed to the motion with the statement of undisputed fact, then it comes back on the other side with the statement of disputed fact and other undisputed facts, and then it goes back for more. So you have like 3 or 4 sets, and everybody's required to file a separate document in ECF. Gets very hard to follow after a while, particularly if there are a lot of facts, but there may be some way to simplify it.
So
Go ahead, Jen.
I think I'm on my.
Yeah.
So I think Judge Smith still has his own rule that you cannot file a motion for summary judgment without first conferring with the judge. And that was the case the last time I checked.
Okay.
So
I didn't pick that one up. Yes, that's a good point, Jen, that you make. If there's any doubt, always reach out to the case manager. But if you go on the court website, and there's a drop-down menu, there are general orders. So it would behoove you to review all the general orders. That first one about the discovery conference, that's a general order. It applies, every judge. But I was unaware of that, and you're right. I think so. You need to find out.
Judges have standing orders that are also posted, but I was involved in a case where the opposing party didn't realize that. So then they filed the motion.
Speak up.
Then they filed the motion.
Yeah.
Then the judge called everyone in because they were supposed to ask before filing. And on the statements of disputed and undisputed facts, I think I had the Pinnacle or Nadir experience with that about a year ago, where the moving party failed to state what the undisputed facts were. But we still had to reply, and obviously we preserved the issue of the failure to comply with the requirement for a statement of undisputed facts, and then played the game of, having not received a statement of undisputed facts, we will seek to divine what those are. And we will then respond to them.
Yeah.
So we went through, these are the things we think they should be asserting are undisputed, and here's our disputation of those things. It went on for 60 pages. It was the most horrible experience I've ever had in a pleading, and then the matter was resolved in a different manner. So I don't even know what the ultimate penalty would have been for the failure to file a statement of undisputed facts other than a do-over. But trying to figure out what you think they're not disputing based on their brief, it wasn't fun.
Yeah. Go ahead, Chloe.
That almost exact same situation where a defendant,
Chloe, put it up to your.
A defendant in one of my cases just filed a motion for summary judgment. He did file a statement of undisputed facts. There are like 9 facts, and then his memo is littered with transcript sites, deposition transcript sites. And I'm like,
That doesn't comply with the rule.
I don't know what to do with that. I don't know how to dispute the sites that are in the memo that aren't in the SUF. I'm like, it's due. My response is due Friday, and I'm like, I don't know what to do.
Just the way I would probably handle that is, I think you need to file a response. But I think right in the introductory paragraph, you say that the motion should be denied out of hand because it doesn't comply with the local rule, and it's difficult to discern what's undisputed and what's disputed in their own motion. But I'll give it a go.
Yeah, I mean, there's certainly
and just to preserve
statements
it
in the memo that I wholly disagree with.
Yeah, and you do want to preserve those statements that you dispute because otherwise it's waived.
It's waived. Oh, which leads to a really good
Oh yeah, we were talking
question.
about
We were
this.
talking about this. So if you don't dispute in your motion for summary judgment an undisputed fact, so plaintiff advances an undisputed fact, you don't dispute it. So it's admitted for purposes of the summary judgment. Is it admitted for purposes of Rule 36? Is it an admission for all purposes? I don't know the answer to that. I would say probably it's a judicial admission. No?
Take a look at our local rule, because I think it addresses it.
I tried to find it. I didn't see it.
All right.
Might be in the new draft. Who knows?
Okay, well, I pulled off the...
Okay.
But you had a question. Go ahead. Sorry.
I guess my question was, is there a reason in your statement of undisputed facts to not just have that be a breakout of like every sentence of the brief, which presumably also needs to be supported by an exhibit or an affidavit or, some kind of...
I mean, that's...
I've seen that.
Yeah, and to the extent that any sentence of the factual portion of your brief that is necessary for you, that is like necessary to support the argument you make later. Sometimes facts are color, right? Like sometimes you're setting the stage when you're telling a narrative, whether like...
Right. So, I mean, your legal memo, obviously you're going to cite the case law and interpreting certain case law that supports your position. But yeah, I think what you see a lot of times is you've got the statement on undisputed facts, and then they're lifted and put in the memo, and there's a citation to statement of undisputed fact number 10.
Yep.
Right? So you have it, it's cross-referenced.
Basically like the same thing.
Yeah. And then you just add the legal argument as to why count 1, 2, and 3 should be granted.
Which is another reason why it's a little onerous, but I'm going to grab that. Yeah.
And Chloe, I was just going to say, I would advise you to contact the clerk because I played that game of trying to go through the whole brief and pull out everything that was actually being asserted as dispute in the brief. It didn't work out very well. It was very muddled. So you might want to just contact Chambers and say, we have a problem here. I think the briefing is not going to assist the court in determining the issue.
Mine might.
Well, yeah.
My motion might.
If you think you've got that nailed, then don't contact the clerk.
Go ahead, Mark.
So, yeah, I just wanted to comment on admitting a fact for the purposes of summary judgment. My understanding is that that's not deemed admitted in the case going forward. In other words, you don't have to prove it at trial. It's not in evidence at trial. In state court, the Rule 56 has a provision that says if the motion gets denied, you can file a motion with the court and deem that certain facts are admitted. And that, in my opinion, you don't have to prove at trial. It's no longer in controversy.
I haven't dealt with that. That's a great practice tip.
Yeah.
So as plaintiff's attorney, you would see that defense asserting certain facts and say, okay, great, you've now admitted that. I'm moving to have those facts admitted for the purpose of trial.
In state court,
Okay.
yeah.
Yeah. So that is then like, it's almost like a request for admission because it's right. Interesting. So now this is very elementary. It's very elementary and sorry, but we are in federal court. So we just talk a little bit about the path of the case. So I think most of us probably appreciate and understand this. Obviously, it's instituted by the complaint with the fee, or you can seek to file in form of papyrus.
How do you tackle the Latin on that one? That wasn't.
Yeah, I know. I took Latin, but the and that gets to like the you'll see that quite often with the prisoner cases of the pro se plaintiffs. And we'll get to that in a little bit. So then what happens once the complaint is filed? Well, the defendant can file a motion to dismiss for lack of subject matter jurisdiction, personal jurisdiction, 12b-6, any number of reasons. And it kind of, at that point, if you opt not to answer, if you opt not to just file your answer and preserve whatever affirmative defenses you're going to preserve, the case kind of stops and track until the motion to dismiss has been fully briefed, argued, and decided. And then, let's say the motion to dismiss is denied. You have 10 days in which to, or 14 days under the federal rules.
But you don't even have to do the math on that, because when it's denied, they'll tell you when
exactly.
the
But the rule says 14 days. You have to file your responsive pleading, which is your answer. And it's at that point that you get your 16B notice of your Rule 16B. Can you go to the next?
Do you have the?
Yes. To the PDF, the next PDF. And by the way, before you get to the 16B conference, you get the notice. Yep. Maybe go down. Yep. Sorry, Megan. Yep. Keep going. Right here. So here's your notice. All right. We're going to have a pretrial scheduling conference before this judge on such and such a date in order to inform the discussion of the merits. This is what you need to do. One, you got to comply with 26F. So what it doesn't say is you're obligated also to comply with 26A. 26A is what? Your mandatory disclosures. Mm-hmm. Don't forget mandatory disclosures, and that does kind of fold into 26F, because after you have your discovery conference under 26F with opposing counsel, you have 14 days to give them your mandatory disclosures, and that is all the documents that you're relying on to support your causes of action, plus identification of relevant witnesses. That's pretty much what you have to produce under 26A. That's your mandatory disclosures. And you have to discuss that. Now you can get to the 16B conference, and we're going to have a conference with the judge. Let's talk about it. What's your discovery plan? And we're going to explore the possibility of settlement before. We can't settle. We could have done this before. I've got to take some depositions. I got to take some depositions before it's ripe for settlement. Okay, fine. Go ahead.
Just quick thing. So another way to reflect how very friendly and lovely this court actually is. In 2015, I was still in private practice. I got handed my first Rhode Island federal court case for a defense firm. It kicked around other places. It came to me, scheduled for Rule 16 conference. Missed the part about preparing a written statement.
Oh, yes.
Yeah, definitely very
Read the
embarrassing.
bottom.
Yep.
7 days prior to. Oh, so what happened?
Got on the phone. I believe it was Judge McConnell, so I'm willing to throw him like how just wonderful and welcoming of a judge he is. He said, "Welcome to the court. I see that you failed to do that. Please be sure to read in thorough," but very nice about it. Very, very nice about it. Like, that's okay. This case has been around for a bit. I know you're new counsel. We'll schedule this again. And it was just very kind and accommodating. It was
yeah, and that's one of the benefits of practicing here. But you do need to submit that. And this is another thing that's unique to our practice here in federal court, that if your local counsel, and I do a lot, my partner and I do a lot of local counsel work. A lot of the big firms do local counsel work, and the smaller firms. And you need to let them know. You got to let them know, because those attorneys that are the main counsel, they have the relationship generally with the client. They want to run the show. You just tell us what the process is, the procedure, and we'll have you review what we file to make sure it complies with your local rules. That's generally how the local counsel roll. In some cases, you have more of a substantive involvement, but others it's just like, look, we know what we're doing. Just tell us what the local rules say. So that's one thing you need to let them know. Can you scroll up, Megan? Thanks. Or down. Yeah, sorry. So keep going. Here's just in a real case, you can see. So this was the notice. Now in this case, it was pre-COVID, telephonic. So the court here, most of your 16B are going to be over Zoom. Some that was telephonic, now it's all by Zoom. And it's the same thing. Let's also talk about referring it to ADR. What are the prospects of doing that? Let's save everybody a lot of money. Our judges love it. Love to engage in discussion about ADR. They want to open and close cases. I think it's a statistics thing.
For just the swift administration of justice, we can
There
take
you
it
go.
either way.
Yeah, can you scroll down too, please, Megan? All right. So now you've got, stop right there. Yep. All right. Now you had your conference. Here's your scheduling order. Now, I want you to scroll down a little, Megan. Just look at the date. We had the scheduling conference, February 15, 2019. Look when factual discovery closes. You talk about a rocket docket. Mm-hmm. June 17th, really? I think in that case, I said, Judge, I can't possibly get done because he wanted it in May. And I said, I'll give you another 30 days, Matt, June 17th. Then you have your expert witness disclosures, et cetera, dispositive motions. I mean, that is well within a year by the time you're ready to try this case.
Were you able to get your factual discovery done by that deadline?
I settled
Okay.
that case. I represented a wonderful nonprofit organization. We sued the city of Woonsocket and had reasonable counsel on the other side, and it was a good result for the client. So didn't have to worry about it.
Let's say you couldn't.
We went to ADR.
Let's say you couldn't.
Right.
So are you bound to this? How rigorous is this?
Well, okay. That's a good question, Eddie. Are you bound? Yes, generally you are, but I think if you need to extend the deadlines, our courts, they're going to routinely grant it. Mm-hmm. It's supposed to be for a good cause. So don't just do a stipulation and expect it to be entered by the court. You have to have some rationale. Oh, the parties are engaged in settlement discussions. We'd like to avoid the judge will be very amenable to that explanation and extend these deadlines.
Absolutely.
Okay.
And
if the case has been around for a while and nothing's been happening, they're not going to be inclined to grant it because they're going to make you feel some pain.
Yeah, absolutely. And I've had a situation where I've extended a few times, and I don't remember which judge it was even, just saying, all right, we're going to do a quick conference call. Just what's really going on? Are you guys actually moving to something? Or are you just buying time? What's actually happening? Kind of letting us know that they're keeping an eye on us and moving the case along.
So I had an observation about that issue.
Sure.
And that is the first one will be routinely granted, but the fifth one will not be routinely granted.
No way.
Because of the timeliness concerns. And therefore, when I ask for extensions in this court, contrast to other courts, usually my desire is I just need a brief extension. But actually, since I know I'm not going to get probably too many other bites at the apple, I might ask for a more generous extension in the first instance.
Yeah.
So that I don't get shut down later and then I'm tied up.
Yeah. So here, this sample example, real case, was a discrimination claim brought against the university. And look at the date of the conference was May 4th, 2022. Judge McElroy said, well, we're going to close factual discovery November 2. Not a lot of time. Mm-mm. Not a lot of time if you want to take a summer vacation. Which, by the way, probably in the 80s and 90s, nothing was happening in either state or federal court for about 2 months. Now forget it. It's year-round, go, go, go in both superior and federal court. Can you scroll down? Thanks, Megan. Appreciate it. All right, I just wanted to share this with you. Okay, you got a hearing. You've got a hearing coming up. This is what you get. I think this is the one I alluded to earlier. Two motions. One is a motion for preliminary injunction on one party, and I had a motion to dismiss for lack of jurisdiction. Motion hearing reset. This is the type of notice you get. Okay, so from that, are you able, it's a preliminary injunction, evidentiary hearing, and then she says, and it's Zoom. It's not in person. It's a Zoom meeting. So I had to call Carrie and say, I want to have a witness. What do I do? It's no witnesses. Are you sure? So you get it. If there's ever any question, call the case manager.
Absolutely.
They're very helpful here. And they won't leave anybody high and dry. If you can scroll up too, please. So, no, I'm sorry, down, Megan. If I say up, I meant down. All right, now you're through discovery. You're through discovery. Now the case is coming up for trial. There's a pretrial conference notice and order, and this is what you have to do in advance of trial. We're going to have a final pretrial. It's going to be a jury trial. Here's what you need to do. How long? You better let me know of scheduling conflicts, a list of witnesses, special needs of any witness, exhibits, and whether testimony will be through deposition, live, blah, 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 blah. And in addition, trial counsel are required to make the following filings and submissions. If you scroll down, please, Megan. Pretrial, like basically your motions in limine. Okay, so your motions in limine, and that's pretty much it. If you can scroll to the next document. Now you've gone through that. Here's your notice. Here's your trial notice. And this is it. We're not moving the date, but please let us know if you settle at 7 days, because we'll slip another trial in place of that. Okay. Filing your voir dire questions. They remind you, don't forget. Otherwise, you're not going to get the opportunity to either question, or you're not going to get the judge to ask the questions you want of. Of course, it's discretionary. The court doesn't. If it's Judge Smith and he wants to engage with the jury pool, he's not obligated to accept your questions. Go ahead.
In your experience, how much of a lead time between receiving the trial notice and the actual trial date have you gotten? Because at least more than 7 days. Right?
Yeah. It's usually. You're going to have a really good. These are kind of old forms, but they're still on the website and they still issue them. Again, because it's cradle to grave with one judge, you're going to have so many conferences with the judge pre-trial. You're going to know, especially if there's a lot of parties. Like I said, this back in the fall, we did this the CERCLA case. There were, 8 parties with attorneys and attorneys from out of state. We were meeting once a week just on scheduling issues. So we knew well in advance, day one, and it was jury waived, thank God. So you're never. I don't think you're going to be caught unaware.
Right.
It's just not going to happen. Not in this court.
Yeah.
You may, when you go to Superior Court and you go to the cattle call and they say, "Oh, you're going to go see, Judge Matos. Mm-hmm. He's ready. You can impanel in an hour."
So I haven't had that experience. I've had more, okay, you're ready for trial. At some point, the trial calendar judge will find a judge for you. And then at some point, you'll receive an email notice with who that judge is. And then that judge will then schedule a time to meet and confer with you.
Yeah.
So it's just
my advice, and just because I'm a proponent of the business calendar, because that's where most of my cases are, either here or on the business calendar with Leach and Stern, look at the business calendar assignment form. And if your case qualifies or falls within the articulated types of cases that can go on the business calendar, take advantage of it. It's cradle to grave on the business calendar, and both Judge Stern and Leach move their cases along. So a little plug for Superior Court and the business calendar. Go ahead, Megan, please scroll down. Let's see. Okay, so we talked earlier about the magistrate judges. So here's sort of the standard order. But the reality of the situation in this court is you can take advantage of the magistrate judges anytime. Yeah. Pre-answer. Pre-answer. I have a case right now. In fact, one of my colleagues is on a settlement conference with Judge Sullivan right now on a case that was filed. I hate to say this because they're going to get angry at me, but it was filed about 8 months ago. And we've had about 3 mediation sessions with Judge Sullivan. And it's a difficult case, a lot of issues, and with the parties. And she hasn't really pressed us, but I think that after today, it's either going to be an answer or some sort of motion. That's the rare circumstance. But the point I'm trying to make is, don't be afraid to utilize the magistrate judges for any sort of ADR proceeding. they're encouraged, they want to help, they're great at it, and it's really cost neutral.
Absolutely, yeah. I had a case with the city of Providence many years ago where, maybe not many years ago, but a few years ago, where post-answer, we thought a mediation with a judge would be appropriate, and we were able to resolve it, and it saved a lot of time and money.
Matt,
Oh, go ahead,
Sorry, I
Barbara.
didn't see my...
if you want to utilize a magistrate, do you need to ask the court for a referral, or do you contact?
Usually you do. Yeah, usually you do. Most times it happens at the 16B conference. Most times. Because by that time you would have kind of sized up the case with the mandatory disclosures, your discovery plan, you have a sense. But really, you can reach out anytime. And they certainly, when you get the trial notice or the final pretrial conference, the judge will press it. The judge will press it. And I don't think that's unlike Superior Court. They're going to see if you can.
Another thing on requesting mediation that's very different in state court, because I encountered this. I was proposing mediation to opposing counsel in this court, and they were really cagey about it and not comfortable. And I was like, what's the barrier here? Well, we don't want to pay for a mediator. I was like, no, neither do I. That is a service that this court
It's unbelievable.
provides. It's like the highest quality mediation at no cost to the parties. So litigants who are not frequently in this court don't realize that, and they may
Right.
be really resisting mediation until you're like, you do know you're not going to be charged for this.
Yeah, it's a
right?
no-brainer, I think. I think it's a no-brainer. It's a great benefit to practicing in this court. Megan, would you scroll down? I think, yep. You can scroll down again. I think so there's just a form, like a notice of settlement conference. See, there's Judge Sullivan. She does them by Zoom, and she has filing requirements, by the way. See, if you look at 1 through 4, so you do basically a mediation statement, lay out what the facts are, what the history of settlement discussions have been. So very much like if you have a private mediator, you're going to include all of these components. Can you scroll down again? Yep. So that's a recent one. Okay, I'm going to finally just keep it on that for right now. Okay. Anything else to add about ADR mediation or the travel of a case, Eddie? Anything that's unique that
Not specifically
you've
with
come
that,
across?
but I do want to go back to just thinking about the local rules. I think that,
Sure.
especially if you're new to this courthouse, if you only think you know a few of them, or if you try to rely on our PowerPoint, obviously, as practitioners, you're held to a higher standard. You can't just look at side notes. You have to look to the rules. And I think that it's always a good practice that anytime you do anything where you look at the federal rules of civil procedure, check to see if there's a local rule. Like, you just want to double check that, and that's just on the court website. But yeah,
Okay.
that's it.
So the last point of discussion for us is to encourage everyone here to consider applying and joining the pro bono panel. So what's that all about? Well, it was a program established a number of years ago. If you can see July 1, 2014 is a letter from then Chief Judge William Smith inviting you. We need your help. We need your help for pro se litigants. And one, it's giving back to your court, to your profession, to those in need. And that's what we're in the service industry, and we need to engage in pro bono practice. I think that there's a moral obligation to give back and to do that. And this is a great opportunity to do it. These are folks who are in really hard circumstances. It could be someone with a disability, a physical or emotional disability who cannot afford an attorney but feels that they've been wrong. They were an employee of an institution and they were terminated, and they believe it was based on their disability. So they come to the clerk's office and say, I don't have anybody to represent me. What do? I want to file suit against my institution. Then it goes to, and Jen and Barbara can speak more to this because they're much more involved in it. Then it goes to a screening panel. It gets the case actually gets screened for the merits, I believe, right?
Not a panel.
A panel reviews.
No panel. Megan and I.
Yeah, please, Barbara. Explain how this works.
Any case that comes in as a pro se case with a motion to proceed in forma pauperis automatically comes to the pro se unit, which is Megan and me and Mike Simoncelli, for those who know him. And we screen them against a plausible claim for relief standard. We make a recommendation to the judge who is assigned, and we generally do that within a week of the complaint coming in. Sometimes we do it that day or the next day, depends how many we have. And the judge then rules on that, and you'll see a text order or an actual order.
Scroll down.
And the order is sometimes
there it is.
relatively short, but per the First Circuit, the order has to explain if you are denying the IFP motion, which technically means the case can go forward, but the plaintiff has to come up with $402.50 right then.
The filing fee.
So it really is the kiss of death for a lot of cases if you deny it. The circuit says we have to explain why the complaint fails the plausible claim for relief standard, and we do. Some of our orders are probably longer than the presiding judge would like to see them. And we often, almost always, will extend a 30-day period to the plaintiff to amend the complaint. And so if we're extending a 30-day period to the plaintiff to amend the complaint, we feel pretty strongly that the plaintiff ought to at least understand what they're supposed to do during that 30-day period. Now, we don't write the amended complaint for them, but we certainly may say that while the legal claims are articulated well, there's a paucity of facts supporting the allegations, or that the standard is for an excessive force case, you need to show deliberate indifference, and you haven't pled that, and you haven't pled any facts from which that can be inferred, those kinds of things. And then it leaves us, except that we are now also doing recommendations on the appointment of counsel. And we are handling the pro bono counsel list. We are recruiting people, we are involved in training people, and we facilitate, or we try to facilitate, the progress of the case on which pro bono counsel are appointed, so that we remain a resource. I'd say 60%, Megan, of the pro se cases are prisoner cases.
Yeah, prisoners. And they're usually, is there about 4 to 5 a year that are handled from the pro bono? Is it more than that?
Oh, yeah. We get now a couple a week.
Oh, so where counsel is actually assigned?
No.
Okay.
Counsel has
that's what I
been
want.
in the past assigned very rarely. There was a pro bono panel, and the idea was that counsel was a very scarce resource, and only in extraordinary cases should counsel be appointed. And there's some First Circuit language to that effect.
Okay.
We use a somewhat more generous standard and think about, will it benefit the court? Can this issue be fairly presented by a pro se litigant? And sometimes it's simply too complex a legal issue. Sometimes the discovery is too complex. But many times some of the stuff coming out of the ACI is very literate. And there's sort of a cluster of 5 or 6 causes of action that we tend to see. The ones from the street are all over the lot. I mean, they are more likely to be the ones that will sue 104 defendants, all the way down from Donald Trump and now Elon Musk to the officer who actually stopped their car.
Yeah.
And 105 claims. They're the ones that actually are harder to deal with.
So what would be the situation under which someone who wants, like even if a mentorship opportunity for a younger attorney, just wants the experience of trying a 1983 action, let's say? How do we get appointed? How do we?
Leah.
We just made an appointment
Oh.
to Leah, who's working with Timothy Baldwin
Oh, that's terrific.
on an interesting case that has to do with the alleged fabrication of positive urine tests at the ACI.
Wow.
And what is the effect
Fascinating.
of that? If it turns out to be true, is that a due process case? Is that an Eighth Amendment case? It's a really interesting legal question. And we just did appoint conditionally. The way it works is that when we appoint you conditionally, and you get a 2-week period, which if you want more time, we'll give you more time, to talk to the plaintiff, look at the documents, decide whether you want to do the case. And at the end of that time, you either enter an appearance or you file a declination of appointment, of representation, no reasons. And in fact, you are not supposed to list any reasons.
Okay.
So
What if
you're not obligated?
If I am appointed, I take the case, but geez, I'm going to incur some deposition expenses. How do is that out of my pocket? Is there a fund?
There is a small fund. And particularly if you're a sole practitioner and you don't have a firm of any size backing you, there's a fund that right now comes from the bar fund of the court, which is an attorney tithe, basically, on the members of the federal bar. And there's a $2,500 limit, which doesn't go very far.
That's not a lot, especially if you need an expert. What happens if you need an expert?
And so the cases we have a lot of trouble with are the inadequate medical treatment cases, more than anything else.
Okay.
Barbara, can you just talk about limited scope and how that's going to work?
Oh.
Can you hear the question?
Limited scope.
Yes. We do
She got it. She got it. Okay, thanks.
occasionally make appointments of limited scope. It may be simply to help a pro se litigant through discovery. We are just doing one now with a guy in an Arizona federal prison who is going to have a Zoom status conference with the judge and probably cannot deal with the mechanics of getting the Bureau of Prisons to facilitate that and may not be able to deal with doing the status conference. So through the court resources in Tucson, they found an attorney to go out and talk to the guy and simply assist him with the mechanics of the Zoom conference. And that's something that if we got a call, I would look to the pro bono panel and say, can you give this an hour or two and go out and talk to the guy and just explain to him what a status conference is.
Okay. That's great. That's great. So go ahead, Lynette.
Thanks.
Can I make a plug for anybody who's doing this?
Yeah.
I don't know whether this pro bono appointment means that you can't associate with the ACLU of Rhode Island, but we're always there to help provide either amicus support or mentorship or possibly additional sponsorship. I know I got roped into a 1969 case that's still pending through a request to look at a case. And we're also here. And one of the nice things about the ACLU is we can troll for clients because we're nonprofits. So if you do have one, feel free to reach out to me at any time, even if it's just to pick my brain or to talk about other approaches. But it's also possible that we can come in and provide assistance as well.
So,
And the Center for Justice, same thing.
Yep.
And a lot of times we collaborate and both come in.
And so I want to just maybe close out our session one by thanking everybody. And I have to make a plug. I know I recognize many of you here, and you're also graduates of our Litigation Academy. So you're very familiar with the good work that was the brainchild of Judge Smith. 12, 13 years ago, we started Litigation Academy. And what it is, it's an academy where we have programs twice a year that engage in a NETA-type program of litigation skills, depositions, direct cross-examination, expert witnesses, oral argument, openings, closings. We kind of cover everything from soup to nuts. And the notices go out. So if you can, it's a great program. Take advantage of it. Eddie's been involved with it.
I've both as a student and as an educator. A lot of people in my office have taken it, love the program.
And another benefit of practicing here is you get that type of program.
Yeah.
So any questions before we close out? Anybody have any questions? Eddie and I want to thank you all for your attention, and Barbara and Jen and Megan as well. Thanks for coming, and good luck with the rest of the program. And feel free to reach out anytime if you have any questions.
I have one thing to add. Because of the limitations of the application we use to take registrations, you can no longer register for sessions. So if there's a future session, and I think there are 3 more, it's been extended to April 22nd because we had to postpone one, just come. And anybody in your firm or anybody you know, just come.
And there are scholarships available for the Litigation Academy. If you have questions, just reach out to me.
Yeah.